Welcome back to City Education, your home for knowledge in all shapes, forms, and sizes. Now, in today's video, we'll be diving into Section 28. We all know that South Africa's environment is a shared heritage, and protecting it is not just a moral duty, it is a legal one. Section 28 of the National Environmental Management Act imposes a broad, protective duty of care on anyone who may cause environmental harm. Today we unpack what this means, how it works, and the remedies which it provides. Now, Section 28 of the NEMA is remarkably broad in its reach. It applies to everyone, whether you're an individual, a private company, a municipality, or even a state-owned enterprise. But it's not just about those actively polluting today. Section 28 also applies to past actions, meaning historical contaminations that may have occurred decades ago, such as old industrial sites, abandoned mines, and former waste dumps. It also applies to current actions. This is pollution or environmental degradation occurring in real time, like untreated industrial effluent or uncontrolled landfills. It also affects future potential harm. Now, these are activities that could cause significant environmental damage if not managed properly. For example, a factory planning to discharge chemicals without proper treatment. It is important to note that if you own, control, or have a right to use land, you can be held liable as well, even if you weren't the original polluter to begin with. This means new landowners, tenants, site managers, or holding companies may inherit a duty of care. For example, in BP South Africa TUI Ltd versus MEC for Agriculture, Conservation, Environment, and Land Affairs 2004, the court held that liability under Section 28 can extend beyond the active polluter to anyone with a connection to the contaminated land. This ensures that historical pollution is addressed and that new landowners cannot ignore past contamination. Now, this broad coverage is crucial for protecting South Africa's environment. It ensures that no one can evade responsibility simply because the pollution happened in the past or because they inherited the land. Section 28 transforms environmental stewardship into a shared, ongoing responsibility for all connected parties. What exactly is the duty of care? Well, Section 28 doesn't just say you cannot harm the environment. It requires active responsibility. This is the duty of care. And it has three key dimensions, which are the preventative duty and the remedial duty. Let's start with the preventative duty. Now here, you must take responsible measures to prevent environmental harm from occurring, continuing, or recurring.
This could include
storing containment measures such as berms or caps on contaminated soil. It could also include modifying industrial processes to reduce emissions or training staff and implementing environmental management systems. Monitoring operations to detect potential harm early also forms within the reasonable measures to achieve protective duty. In the case of EarthLife Johannesburg versus Minister of Environmental Affairs 2017, the court stated that the duty of care requires proactive steps to prevent harm, not just the reactive measures after pollution has occurred. Now let's move on to the remedial duty. Now here, if pollution has already occurred or harm is unavoidable, you must take reasonable steps to minimize and rectify the impact. These could include investigating and assessing environmental damage through soil and water sampling, risk assessments, and environmental impact report. It also includes stopping the polluting activity immediately or mitigating ongoing effects. Another thing that's included is the removing of pollution sources such as excavating contaminated soil or treating affected water. Restoring the environment to its prior condition or at least an acceptable state is also included under remedial duty. It is important to note that reasonable measures are not context-specific. What is reasonable for a large industrial facility may differ from a small municipal operation or a homeowner. The law is flexible but clear. Action is mandatory in proportion to the risk and damage. Section 28 turns environmental protection into an active duty, not just a passive right. It emphasizes foresight, vigilance, and accountability, ensuring that environmental harm is prevented where possible and effectively remedied when it occurs. Now, as we've already touched on, Section 28 of the NEMA makes it clear that liability is not limited to the person who caused the pollution. Responsibility extends to anyone connected to the land where the pollution occurred. This includes the owner of the land or premises, whether they created the pollution or not. No. 2, the person in control of the land. This could be the tenant, site manager, or holding company overseeing operations. No. 3, a person who has the right to use the land. For example, someone with a lease or other legal entitlement. This means that if you acquire land that is contaminated, you may inherit the duty to investigate, contain, and remediate the pollution. In the case of HTF Developers Pty Ltd, this is Minister for Agriculture, Conservation and Environment KwaZulu-Natal. The court confirmed that liability can pass to successors in title or new land owners. Even if they didn't create the contamination, they were responsible for taking reasonable measures to address it. In the BP South Africa Pty Ltd, as Minister of Agriculture, Conservation and Environmental Land Affairs case, it was reinforced that liability under Section 28 extends to those in control or with a right to use the land, not just the original polluter. Now, the broad scope of the liability ensures that environmental remedies
is not stoked
by change of ownership or control. It also protects public interest, making sure that historical contamination does not go unaddressed. In short, Section 28 ensures that every person connected to the contaminated land has a role to play, reinforcing the principle that those who benefit from the land also share responsibility in its environmental condition. Now, Section 28 does not just rely on voluntary compliance. When a person fails to meet their duty of care, the state has powerful enforcement tools to ensure environmental protection. The Director General of the Department of Environmental Affairs or the provincial head of department can issue a directive, a formal order requiring, firstly, investigation and reporting of the environmental impact, secondly, diligent commencement and completion of a specific responsible measure, thirdly, compliance by specified deadlines. If the directive is ignored or not properly implemented, failure is considered an offense under the National Environmental Management Act, triggering further action by the state. The Director General or provincial head of department may firstly take the required remediation measures themselves, or secondly, recover all reasonable costs from the liable party. Yet again, in the EarthLife Africa Johannesburg, thus Minister of Environmental Affairs 2017, the court highlighted that the state can enforce compliance through directives and ensure that the polluter takes responsibility. The duty of care is not optional. The law empowers the state to compel action. These enforcement tools are critical to making Section 28 more than just a legal principle. They transform environmental protection into an actionable duty, ensuring that the environment is not left vulnerable due to inaction or neglect.
It is a system
designed to uphold the polluter pays principle, safeguard public resources, and guarantee that remediation occurs efficiently and effectively. Now, Section 28 empowers the state not only to enforce environmental duties, but also to remedy the situation directly if the liable party fails to act. If the Director General or provincial head of department issues a directive and the party does not comply, the state can undertake the remediation measures itself. This could involve hiring specialist companies to remove contaminated soil, treat polluted water, or restore degraded land. It could also involve installing monitoring systems to track ongoing environmental recovery and implementing long-term management plans to prevent recurrence. Now, once the state has acted, it can recover all reasonable costs from the liable party. Importantly, the scope of the liability is broad. It may include anyone responsible for or who contributed to the pollution. the landowner at the time the pollution occurred or their successor. It may also include anyone in control of the land or with rights to use the land at the time. It may even include any party negligent in failing to prevent pollution. In BP Southern Africa, Private Company Limited versus MEC of Agriculture, Conservation, Environment, and Land Affairs 2004, a demonstration of how the state recovered remediation costs from liable parties, reinforcing the polluter pays principle, occurred. Now, this mechanism creates a strong financial deterrent. It ensures that environmental remediation does not become a burden on taxpayers, and that parties responsible for the pollution are held accountable. By combining the ability to take action with the power to recover costs, Section 28 transforms environmental protection from a theoretical principle into a practical enforceable responsibility. Effective environmental remediation requires access to neighboring land. For example, installing groundwater monitoring bores, containing pollution spread beyond the property boundary, and even treating affected soil or water that extends into adjacent sites. Now, if access cannot be secured voluntarily, Section 28 empowers the minister to expropriate the necessary rights such as servitude to enable remediation. Now, the costs of this expropriation are not borne by the state. Instead, the party benefiting from the remediation, usually the polluter or landowner, is responsible for reimbursement. This ensures that, firstly, the environment is restored without delay, secondly, the financial burden does not fall on the public, and thirdly, accountability is maintained in line with the polluter pays principle. Yet again, in EarthLife Africa Johannesburg versus Minister of Environmental Affairs, the case highlighted the proactive measures that the state can take to secure land access and enforce remediation, emphasizing that Section 28 provides practical solutions to real-world obstacles in environmental management. Now, by granting the minister the power to expropriate access rights, Section 28 removes practical hurdles that could otherwise stall cleanup efforts. It ensures that remediation is effective, timely, and legally enforceable, even when cooperation from neighboring landowners is not forthcoming. In essence, this provision shows how Section 28 transforms environmental protection from a legal principle into actionable, enforceable stewardship, leaving no room for inaction. At the heart of Section 28 is the polluter pays principle. Now, this principle ensures that those responsible for environmental harm are also responsible for paying the costs of remediation. Section 28 transforms environmental protection from a passive right into an active duty, backed up by enforcement powers and cost recovery mechanisms. It ensures that, firstly, the environment is restored efficiently. Secondly, liability is broad and includes not just the original polluter, but also owners, controllers, and users of land connected to the pollution. And finally, financial responsibility is placed on those who caused or benefited from the pollution and not taxpayers or the public. Now, Section 28 also ensures that environmental stewardship is forward-looking. It covers historical, present, and potential future harm, compelling all connected parties to act responsibly. In practice, this means contaminated sites are not left as often liabilities. Secondly, landowners and tenants understand their legal responsibility. And thirdly, the public is protected from bearing the financial burden of environmental degradation. Ultimately, Section 28 creates a robust framework for environmental justice, ensuring that South Africa's natural resources are protected, restored, and managed sustainably. In conclusion, under Section 28 of NEMA, everyone connected to the land has a duty of care to the environment. It is a powerful reminder that environmental stewardship is a shared responsibility with a serious legal consequence for neglect. The environment is not just a resource, it is a trust, and everyone has a part to play in protecting it. If you found this video helpful, don't forget to like, share, and subscribe. This is City Education, your home for education in all forms, shapes, and sizes.